My name is Bill O'Brien. I'm with O'Brien Law, and the focus of my practice is primarily personal injury.
I'm Kevin O'Brien, partner with my brother in our law firm, O'Brien Law. I focus on estate planning, but also we are a general practice as well. We do other things besides that. I always tell people when I'm speaking like this that if we don't handle the kind of work that you need for a lawyer, that we will find the right person to do it for you. So, come to us first and we'll help you get to the right place if we can't do it. Bill became a partner in 2001 with us, but before that we started the law firm of Penny, Botticello, and O'Brien back in 1990. Unfortunately for us, those two guys are retiring at the end of 2018, and Bill and I are going to continue on, and so we're going to be moving the law firm from Penny, Botticello, and O'Brien to the new law firm, O'Brien Law.
It's a dream that we always had. We wanted to practice together, and I get back to our father. I think he'd be very proud to have his sons in a practice together.
People have asked us, why is it you both became lawyers? Your two brothers, how is it that two brothers became lawyers? Bill and I became lawyers because of our father. Our father was very interested in the law, and he had a lot of respect for attorneys. He led us to the profession.
Yeah, as a child, we would always ask him questions about the law. When I was in about 8th grade or so, Kevin got the word that he was accepted to law school, and I was really surprised that my father was just overjoyed by it. And at that point in time, I decided that I wanted to be a lawyer. Later on, unfortunately, my father passed away at a very young age. Young age for me and for him. He was 59 and I was 18. But Kevin always encouraged me after that to pursue the law degree. I went to work for the insurance companies for a while, and then went to law school evenings, and then I was really I got involved in doing insurance defense work for the Travelers and for the Aetna. And then Kevin convinced me to leave the dark side and to join him. And so it was a great honor to practice with him, and I look forward to many years doing so.
The people that we deal with in our practice are Manchester, Bolton, this community, this Eastern Connecticut, modest people who don't have a lot of money generally. So our fees are modest to match that. Partners sort of with them in their case, and so if they're successful, we're successful, and if they're not successful, then we understand the risk too. So,
yeah, I think we have a lot to offer in terms of the fact that you get a lot of the larger, what I refer to sometimes as the big box law firms that advertise a lot. They really can't offer the personal service that we have, where you can reach me, you can contact me. I have a paralegal that works for me, and if you have a question or concern, what I generally tell clients is that basically, once they contact me, their primary responsibility is to do what they got to do to take care of themselves and get themselves better, and we'll take care of all the other stuff as far as the legal end of it. Alleviates a lot of anxieties.
Yeah, some of the big firms that advertise a lot, you go there, you may never meet the lawyer that you saw in the advertisement, ever. As your case progresses over the 18 months or 2 years that it takes, you may be assigned to 3 or 4 different lawyers who come and go in that law firm. When you work with Bill on personal injury, you're going to have Bill from the beginning, in the middle, and in the end. And when you call and you need a question answered, Bill's going to be there to answer it for you.
I've been on both sides. I've had the opportunity to see the insurance side of it from the claim standpoint. I've done insurance defense work, and I understand how the inner workings of the insurance companies are in terms of how they evaluate cases and how they evaluate risk and how they evaluate attorneys. And I think what I take from a lot of my experience is the fact that I have a lot of trial experience, and my approach to a lot of the cases is to work the cases up as if you're going to trial. Basically, what the judges will tell you is that 95% of the cases that do settle without going to trial, but you have to be prepared to go to trial, and if you work the cases up to go to trial, the other side will know that you're ready to try the case and go forward. The first thing that we tell clients is, number one, as far as an initial consultation, it's free. There's not a charge for that. There's a sliding scale in the state of Connecticut in terms of the value of the case, but for most cases, it's usually settled for a third of whatever the recovery is. We front the costs on it. If for some reason, if we go through the process and there was not a recovery, the client would not be responsible for any cost at all. doesn't cost the client anything either way.
So costs are something like perhaps you had to go to court. The court charges a fee to file papers. You may have to hire a marshal to serve papers. There may be reports that are required from a doctor. You may have to actually hire a doctor to give you an opinion. Some of these costs can be very expensive, and we do not charge our client that money up front. And if they're not successful in their claim, if the claim doesn't work out, we don't ask them to reimburse us for that. We'll eat that. So we don't want to have any risk on the client's part.
When a client first comes into office and a lawyer tells them that they know what their case is worth, they're making a big mistake, you really don't know. Normally, I wait a year, and they refer to that as what they call maximum medical improvement. Basically it takes a year after an injury to reach an end result and see where you stand medically. If a client has to have surgery during the process, then usually it's 1 year after the surgery is done that they've reached what they refer to as maximum medical improvement. And at that point, we're in a position to evaluate the case. The way that's normally done is that we send them back to their treating physician and ask them for a final evaluation. And at that point in time, the doctor will come back and tell us whether or not there's any kind of a permanency, if they have a permanent partial disability, what the future medical expenses are going to be. And at that point in time, once we've gotten to that point, I'm in a position to evaluate the case and to sit down with the client and talk about the values and talk about an appropriate demand to the insurance company. But I really think that it's a mistake for any attorney really, to give a client right in the beginning an idea as to what the case is. Some people have very successful recovery. Some people have a lot of problems with lifelong issues, and it takes a long time for things to shake out. So usually I advise clients, as a rule of thumb, basically to wait a year before we try to evaluate the case and put a number on it.
Yeah, Bill's had cases where it seems in the very beginning that it's a relatively minor case, and the insurance company has called the client up and offered them maybe $3,000. Well, it turns out after they've gone through treatment and the doctors have got involved and they've seen how serious the injury is, the case could be worth much, much more than that. And so that it would have been a real shame if people had settled early. So putting values on the case early is not a good idea, whether it be the insurance company doing it or the client or the lawyer.
Yeah, I had a dear friend of mine who was involved in a car accident, and the other driver ran a red light and totaled his car, and it appeared to be a minor injury at the time, and he was proceeding with the fact that it was a neck, what they referred to as a soft tissue injury type case. But as time went on, he started to have some issues as far as his vision and discovered the fact that he had suffered a fractured orbital and a traumatic brain injury. That was a real lesson to me in terms of the fact that you really have to wait and make sure that we know exactly where the client stands medically in terms of any type of issues, and then we're in a position to better evaluate the case, with the insurance company.
So some people ask us, why do I need a lawyer to do my estate planning documents? I could go online and I could figure out how to do a will. Everybody knows there's companies out there that you can go online and you could create your own will. But by having an attorney do it for you, you're going to have an experienced attorney look at your estate, look at what you own, look at who your heirs are, and make sure that what you want to see happen does happen. When people come to see us for these estate planning documents, usually it's after many years of anxiety and advice from their financial advisor or their family, and they finally just bit the bullet and they've come in to do it. And when they come in to do it, they want it done right, obviously. They want the peace of mind that, I took care of that problem, it's done. So when you do it yourself, the problem is you're not sure that it's right. It's a document that you want to have peace of mind after you completed it, and the right way to do that is with an experienced lawyer just like ourselves. The basic documents are a will, a power of attorney, and healthcare directives. Sometimes that's called a living will. Those are the three documents that are basic to almost all estate plans. Some people may need more complicated plans than that, for example, a trust or something like that. But they want to have a will, and a will makes sure that whatever you own passes upon your death to whomever you want to make sure it gets it. If you don't have a will, if you die what the law calls intestate, then you're leaving it up to the state of Connecticut statutes to decide where your property is going to go. Now, the state of Connecticut or the town doesn't take your assets, but the law has presumptions. They presume, for example, that you want all your property to go to your spouse, or you want your property to go to your parents or to your children. If you don't have a will, you can't fine-tune that to make sure it goes exactly where you want. You may have a disabled child, for example, who, if they inherit your money without a will, all that money might go to the state of Connecticut to pay for their care. There's a way that you could preserve that money for the disabled child's care if you had a will. So there's a good reason to have a will. You also want to have a power of attorney. That's another basic document. A power of attorney is a financial form that appoints someone to be your agent to act for you financially. So that doesn't necessarily have to do with getting old or deteriorating, but often it is used for that purpose. So in the future, if you become disabled and you're not able to go to the bank and pay your bills or access your investments, your agent can do that for you. So a power of attorney is a financial document that allows your agent, your family member, your wife, your husband, the ability to get to your assets and pay your bills for you. The last basic document is the healthcare directives, and that's what people call a living will sometimes. If you've ever gone to the hospital for almost any reason, they say, do you have a living will? What that is, again, is a document that says, if I'm dying, if I'm about to die, I don't want to be hooked up to machines and be kept alive. A machine like a respirator or a feeding tube. You say, I do want to have sufficient pain medication. I want to be medicated so I'm not in a lot of pain, but I don't want you to prolong my dying. If I'm going to die naturally, let me die naturally. So in this form, you could state those facts. I don't want to be hooked up to machines in that event. You can also, in this healthcare directive, appoint a healthcare agent. That would be, again, similar to the power of attorney, but this agent would make healthcare decisions for you if you can't make them yourself. So you can imagine you're in a hospital and you need surgery and you can't talk. The hospital says, look, you need to have surgery. They can't talk to you. They can't ask you. So in this document, you've appointed someone to say, this is what that you should do, because you've indicated in the form, this is the person I trust to make good decisions for me. So those are the three basic documents. People often come to the office and they say, look, I saved up all my money over these years, and if I have to go into a convalescent home, I don't want it all to be spent on the convalescent home. I want something to pass on to my children. And I frankly hear that question, and other lawyers do all the time, because people have talked to their friends about it. They've seen it happen to their relatives. It's a serious problem as you get older. If you don't have the money to pay for a convalescent home, then the state of Connecticut with the federal government is going to pay for it. And it's a form of welfare. The state, and you can imagine, the government doesn't want to be paying for convalescent care if you can afford to pay for it yourself. But people still say, well, what can I do to try to preserve my assets? So there are techniques that are available. Some people have heard about a look-back period of 5 years. So you can give everything away and hope 5 years goes by, but that's not usually a very wise thing to do. So there are techniques that are available, and we know how to do that. We make plans for people on how to do it. All of it's legal. Nothing's improper. It's all accepted by the government, and it's been tested in the courts. So there are plans that we can come up with to help people preserve their assets, but that's very particular. Depends on precise information that we have from the clients and their family about what they own, and it is possible, but it's not simple. Jointly owned property is an excellent way to own property almost all the time. Sometimes it's not. It's not 100% of the time. But joint property means that each owner owns 100% of the property, which is a legal fiction. You can imagine if you own something jointly with your husband or your wife, you own all of the property yourself. So if one person dies, the survivor continues to own the property. Nothing is passed to them as a result of death. So nothing has to go to probate to change the ownership. There's no change in ownership. So it's a good way to handle property, to have it jointly owned. The problem is when the second person dies, where is it going to go there? So it's good to have jointly owned property, but it's also good to have a will to make sure that upon the death of the second joint owner, that the property passes again the way you want to see it pass. Some people ask us, can I avoid probate? What if I have a trust, a living trust, for example? The answer to that is in some situations, yes. There are particular situations, though. Let me first of all tell you what a living trust is. And you could transfer your property into this trust so that when you die, nothing passes as a result of your death because you didn't own it. The trust owned it. And a trust can't die, so the trust doesn't go to probate. So in history and in other states, a living trust was a way to avoid having to go to probate. Connecticut is unique, I think, in all the states, because Connecticut still is going to ask what property you owned in a living trust when you die. And they're going to ask that because they're going to collect a fee based upon the value of what was in that trust. So if people are trying to avoid paying the fee to the probate court, a living trust is not the way to do it, because you can't avoid it.
This gets into the same issue that Kevin talked about in terms of representing yourself. You can do it, but you run into a lot of perils. One of the concerns that you run into with representing yourself is that you only get one opportunity to get compensated. Once you sign a release or with the insurance company, the case is over. So you can't come back 2 years from now or 10 years from now if you didn't feel you get fairly compensated. I believe, as an attorney, that you need somebody in your corner to advocate for you. If you represent yourself, often you're dealing with claims professionals, and they have had different obligations. They have, number one, an obligation to their insureds to get the case resolved, but also an obligation to their employers. Another big issue that you find is the fact that they do this day in and day out. So if you're dealing with a claims adjuster or a claims supervisor, you run the risk of not getting fair compensation for your case.
But I have no intention of retiring in the near future. I don't have any plans whatsoever. I think that we're probably going to be together for another 5 or 10 years before I decide to move on. We are excited and enthused about this change and looking forward to just the two of us working together. So,
Absolutely.